Good evening, everybody, and welcome to our Wednesday night AJ Zoom series. My name is Tennille Murray, and I am the Community Engagement Director at AJ. I can see there are a lot of people online here with us on Zoom. Great to see such a fantastic crowd coming in live to watch us. We are also live on Facebook, so good evening to all our guests watching on Facebook and to everyone who is watching the YouTube recording or listening in on J-Air. We have a fantastic evening planned for you this evening. And before we begin, I'd really like to give a thank you to Ian Warby of Christians for Israel, who has partnered with us for this event tonight. The two guests that we will host tonight are regular contributors to the free newspaper that raises awareness and support for Israel called Israel's and Christians Today. It's fantastic. We love to partner with our supporters, and we really do appreciate support from the community and beyond. Tonight we're talking lawfare, the legal war against Israel and how to fight back. We have two fantastic speakers from thinc. We have Andrew Tucker and Professor Greg Rose who will present this evening. Israel is attacked on all fronts. One of the most concerning developments is the abuse of the law to target the Jewish state. Our first guest, Andrew Tucker, studied law at the University of Melbourne and Oxford and is now based in the Netherlands. He is the co-founder of the Hague Initiative for International Cooperation, a European-based global network of lawyers that engages in research, education, and legal diplomacy to fight the delegitimization of the Jewish state of Israel and promote the fair and equal opportunity of the application of the law to support international cooperation and development. Pardon me, but our first guest will actually be Professor Gregory Rose, who is an Honorary Professor of Law at the Australian National Centre for Law, and he is also part of thinc, that is the Hague Initiative for the International Cooperation. We're so pleased to have these really fantastic, educated guests this evening, and I'll hand over to our first guest, Professor Greg Rose. Thank you so much.
Thank you very much, Tennille, and thank you for inviting me. It's a pleasure to be here. I'm going to be speaking this evening about lawfare against the Jewish state, and I'm just going to share my screen because I will be relying upon a PowerPoint. There, can you see the opening slide? Just nod if so. Good, thank you. I'll be talking about the context of lawfare, its impacts, the battlefields that it takes place upon, and the dilemmas that it poses us with today. Now, the war against Israel, currently there's the seven-front war from the Houthis, Hamas, Hezbollah, the West Bank, Iran, and cohorts in Syria and Iraq. But that's just the kinetic aspect of the war. It's actually a multi-dimensional war, sometimes called a hybrid war. The Center for Strategic and International Studies in Washington pioneered the phrase of the gray zone, the contested area between routine statecraft and open warfare. That is the limbo land between peace and war. And it's typically diverse, high-tech, integrated across multiple dimensions. And it involves military ambiguity. So, for example, ramming or catching the nets of naval vessels in the South China Sea, economic coercion and boycotts, cyber intrusion, disinformation. And disinformation is the aspect I'm going to focus on tonight, which has a multitude of objectives: to influence elections, demoralize a country or its army, to demobilize its army, for example, to encourage reserves not to report for duty, and to delegitimize the country. What does delegitimization mean? This is the term that relates particularly to the legal sphere of activity, to frame Israel as a criminal state, a terrorist state, an illegal state. And the impacts of a successful delegitimization operation generate a fall in international solidarity with that state. It may result in interruption of trade supply and a breakages in the logistics supply chain, such as chemicals that have been refused for loading in Gibraltar and in other ports where they're destined for Israel. International influence declines in international bodies. Individuals are criminalized, unable to leave aeroplanes when they land in London. We had Ayelet Shaked prohibited from entering Australia last November. And it also reinforces the hostility of the enemy, because the enemy then has the reinforcement and the validation of the law saying, yes, you're right, the people that you oppose are a criminal organization. One of the unintended side effects of delegitimization in the context of lawfare is it also undermines the rule of law and the integrity of legal institutions. And I'll speak more about that in a moment. So lawfare tactics misuses the law by applying it in extraordinary ways other than those for which it was designed. Otherwise, there wouldn't really be any sense in calling it lawfare. It would just be litigation, because every court battle is a form of conflict. But what is it that makes conflict in international law into lawfare? It's the misuse. It's applying it in ways that it wasn't intended to. So, for example, humanitarian law, the whole purpose is to protect civilians and those that are outside of combat, the wounded and the sick. But if we perversely put civilians in harm's way to leverage humanitarian law, then we undermine the basic purpose of humanitarian law, which is to protect civilians. So if we fire from behind children, or we embed our guerrillas within civilians, or we put our bases within and under hospitals, the enemy that is the target of this tactic either has to abort combat or harm the innocent in the process of striking the combatant. So it's a lose-lose situation for a country like Israel, which either can't act or is going to be accused of disproportionate or deliberate harm against civilians. There's been controversy over the definition of lawfare. There are a range of academics here who have developed definitions. The one on the bottom left-hand side, Charles Dunlap, was the originator of it. And Ord Kitri, who's on the top left-hand side, is the person who associated it specifically with leveraging the compliance of one side so as to create a disadvantage. And then we add to that the idea that that leveraging is actually a perverse subverting of the purpose of the law and the rule of law. So then we come to a definition where lawfare combines law and warfare in the theatre of war, in the field of ideology, and we note that ideological attacks against Israel are usually successful when conducted through the legal machinery of international law. We live in an age of global legalism, a highly regulated society, sophisticated international networks, and rapid growth of international law and institutions. And here we have Judge Ruth Bader Ginsburg, may she rest in peace, who was a symbol of the rule of law and of feminism, and part of this global ideal that has really sprung from largely from the mind of the European model, where the EU is a polity of states united federally under law, and you write that large and you have a global society under law. But within the law courts of this global society, a clash of civilizations is being played out. Since the end of the Cold War, as predicted by Samuel Huntington, the clash of civilizations between Western liberal democratic ideals and more tribal and religious patterns of social organization are being played out. And those battle spaces are international, regional, national, and local. It's an all of society, all of the world's conflict. And when we look at Israel, a small blue sliver there on the eastern end of the Mediterranean, it's 1/200th the size of the surrounding Arab countries, 1/600th the size of the Muslim world geographically, I think 1/50th of the population of the Arab world, 100th of the population of the Muslim world, and you can see there are 22 Arab League states, 57 states in the Organization for Islamic Cooperation, and just one Jewish state in the world. So obviously Israel is outnumbered. And then, of course, the numbers are leveraged further because about half of the 55 now countries in Africa are Muslim, and Africa votes as a bloc typically within the African Union. And then you have neighbor countries in West and South Asia. You have East Asian countries heavily dependent upon oil, which is leveraged to advantage by the Arab bloc. And so it's typically very easy to leverage up from 57 Organization for Islamic Cooperation votes to double that number to about 120 votes. There's an automatic 120 votes in the UN out of 194 members. And in any vote, there's usually about 20 countries missing. So you've got 120 out of 174. It's a 2/3 majority on any resolution, including that the earth is flat and white is black. So if we focus on these UN battle spaces for lawfare, primarily the International Court of Justice and the International Criminal Court, we'll see how these majorities play out. But it needs to be borne in mind that it's not just the law courts, but also the General Assembly, the Human Rights Council, the UNESCO and World Health Organization, amongst others, where the same numbers play. So, we've seen the UN Secretary General at the time, Kofi Annan, condemn the UN Human Rights Commission for its unremitting bias when it was composed as a commission of 54 members. It was reformed in order to try and specifically deal with the bias against the Jewish state, but the membership composition is essentially the same problem in the Human Rights Council as you have in the General Assembly. UNESCO, the US has withdrawn from, Israel has not been a member of, and in over the last decade, more recent years, the World Health Organization has also been mobilized in this battle space. And that gives rise to, a range of anti-Israel resolutions. There has been an emergency session number 10 in place concerning the situation in Palestine ever since 2002. So for a quarter of a century, the General Assembly has been in a rolling emergency session. In 1975, the only resolution that the General Assembly ever disavowed was adopted. The 1975 Zionism is Racism resolution, adopted, engineered by the Soviet Union at the time to court the Arab vote and wedge the Arab and Islamic world away from US influence, which was then rescinded at the end of the Cold War, the only time that that has happened. And within the UN organs, you have a division. There are only 5 divisions, but one of them is for Palestinian rights. And there's an special information program on the question of Palestine, an annual day of solidarity, about 5 million annual budget allocations within those secretariat functions, but no such programs for any other people. And of course, Antonio Guterres has been infamously snapped in a confab photo with Yasser Arafat from the early 70s, and is now barred from Israel as a persona non grata, which is an extraordinary step to take against a UN Secretary General. And then beyond the Secretariat, the intergovernmental bodies that have been created under the General Assembly include a Committee on the Exercise of the Inalienable Rights of the Palestinian People, a working group on the financing of the UN Relief and Welfare Agency for Palestinians in the Near East, a Conciliation Commission for Palestine, And again, no special body for any other people under the General Assembly. I won't spend time on UNRWA, which has been in the news so much lately, but it involves 22,000 Palestinian staff, and the staff union is controlled by Hamas, and that explains a good part of its support for Hamas. Its regular budget is about $500 million, and additional gifts to it raise its annual budget to close to $1 billion. So this is the landscape of the UN. Within the Human Rights Council, the Special Rapporteur Francesca Albanese, appointed to safeguard the inalienable rights of the Palestinian people, has conducted an investigation globally of private sector companies supporting Israel in Judea and Samaria, otherwise known as the West Bank. And those companies are then listed for boycott because Zionists are said to be in breach of human rights, and companies supporting them are in breach of their environmental, social and governance social contracts, supposedly. But how does this actually play out in reality? Well, in Melbourne, in the southeast, I think Narra Warren, Julian Hill, who's a member of the House of Representatives, has requested the Australian Tax Office to challenge the tax deductibility of the JNF, the Jewish National Fund, because it supports forest and other activities in Judea and Samaria, otherwise known as the West Bank. So there are repercussions of this international discourse and tsunami of lawfare actions abroad at home. And I'll speak also more about that momentarily. Within the courts, you have the statute of the International Court of Justice at the back of the UN Charter, which lists the sources of international law, and the judges themselves then draw upon these sources to formulate rulings. And in the case of Israel, there's a multitude of rulings. An advisory opinion in 2004 that I'm about to speak about, a case against the US for moving its embassy to Jerusalem brought by the state of Palestine, the advisory opinion on the occupied Palestinian territories, as they're termed, in 2023. There was a request put by the General Assembly. Then in 24 on the obligation of Israel to cooperate with UNRWA, the UN Relief and Works Agency. The genocide cases that are brought in 2024, one against Germany and one against Israel. And typically these are brought at the end of the year in December, where there are very short deadlines decided just before Christmas on turnaround times to make it more difficult for countries to respond. The picture that you see here is Andrew's beach resort in The Hague, which is the Peace Palace, the seat of the International Court of Justice, built by Andrew Carnegie as a gift to the League of Nations. It was originally the home of the Permanent Court of International Justice of the League of Nations, now of the International Court of the UN. So in the advisory opinion that was first requested in at the end of 2003, during the Second Intifada, when Israel was constructing the separation barrier between Israeli towns and West Bank towns, the General Assembly requested an advisory opinion from the International Court on the legal consequences of that construction. So the court has two kinds of jurisdiction: advisory, which is to advise the UN on how to conduct its business and its legal obligations, and disputes jurisdiction concerning conflicts between states. In this case, the court decided it had jurisdiction, that this was not a dispute, but rather just a matter for advising the General Assembly, and it found that Israel had violated Palestinian human rights and the right to self-determination, that there was no right of self-defense in international law against terrorism, and that Israel had no legal defense in a doctrine of necessity, and that therefore Israel must dismantle the separation barrier and pay compensation. That sounds very much like a judgment in a dispute, but nevertheless it was framed as a general advice to the General Assembly, and it's relevant today. The map that you can see on the right-hand side shows the path of the separation barrier where it enters into and surrounds Israeli villages in Judea and Samaria. So it's relevant today because it relates to self-defense, which we're also about to come to. Last year's delivery of an advisory opinion found that Israel's continued presence in the occupied Palestinian territories is unlawful, must be ended as soon as possible. All settlers are to be evacuated. That's about 500,000 people. And that Israel must make reparations for damage caused. So you might think that this seems a little disconnected from reality. It resulted in the General Assembly calling a conference that was to be held earlier this month on the fulfillment of Palestinian self-determination and sovereignty in accordance with the judgment of the court. But the conference was postponed with the outbreak of the war that we have just seen concluded by a ceasefire between Israel and Iran. And here again, international law comes up where under the UN Charter, states have an inherent right to self-defense. That is a right that pre-exists the Charter. It's inherent in their existence as a state that they can protect their continued existence. And so we have legal experts such as Marko Milanovic or Ben Saul saying that Israel has committed an act of aggression against Iran in its attack on Iran 2 weeks ago. But again, without looking at the contextual facts of that there's been a war ongoing, at least since the 7th of October 2023, when Israel was attacked by Iran's proxies, and that Iran has already attacked Israel directly in 2024, not even through proxies. But even if one disregards the continuing war and that Israel's targeting of Iranian military facilities was part of its self-defense, one can still argue a doctrine of preemptive self-defense in anticipating an imminent threat, a doctrine that goes back to the 19th century, and where the scope for taking preemptive measures increases in relation to the gravity of the threat. Where you have an existential nuclear weapons threat, then one would expect that more preemptive, preventative latitude would be allowed. But not according to anti-Israel scholars, who would argue that it's the crime of aggression and that it should be another cause for prosecution of Israel in the International Criminal Court, which is already a theatre of lawfare. The Mavi Marmara case, that was a blockade breaching vessel from Turkey registered in Comoros in 2010, which resulted in a whole series of cases in the International Criminal Court. And then, of course, Greta Thunberg and her friends earned notoriety in the arrest of the Madeleine, another vessel sinking to breach the blockade a few weeks ago. Within the International Criminal Court, there's the case against Israel called the situation in Palestine. There are the warrants that have been issued against Bibi Netanyahu and Yoav Gallant for genocide and starvation and illegal conduct of war. This is the International Criminal Court, which also has its home in The Hague, a stone's throw from the International Court of Justice. The Hague posits itself as the home of international justice. But the flawed reasoning that's used in the International Criminal Court and the International Court of Justice and in General Assembly resolutions ignore relevant facts and legal history, including Security Council Resolution 242 adopted in the wake of the Six-Day War, and the existence of the Oslo Accords as binding legal instruments governing the Israeli-Palestinian conflict. So in the Six-Day War, where Israel conducted a war of clear self-defense, a resolution was adopted that called for Israeli withdrawal from territories, not all the territories, but from territories occupied in the recent conflict, termination of all claims and states of belligerency, together with the right to live in peace within secure and recognized boundaries, where secure boundaries suggests some shift in boundaries, free from threats or acts of force. So this was a binding Security Council resolution. And the Oslo Accords remain binding today. And you can see in this little map, the light gray area is the area under Israeli civil and security jurisdiction. And the green area is the area under Palestinian civil and security jurisdiction, whereas the orange areas are under Palestinian civil jurisdiction and Israeli criminal jurisdiction, as per the Oslo Accords, which have not been disavowed by the Palestinian Authority, in fact, were recently reaffirmed. So sovereignty is disputed, really, in the West Bank and the Gaza Strip. But when you look at the competing claims to title, Israel's claim would be superior based upon international law, which has its roots in the League of Nations mandate that was inherited by the UN, in the actions for self-defense Israel took, in the wars of annihilation against it, and in the legal doctrine of uti possidetis juris, which is that a state inherits the boundaries of the previous polities. So at the end of the British colonial rule in Uganda, that the boundaries of Uganda were the boundaries that the British left. At the end of the British Mandate, the boundaries of the country were those that were left by the British Mandate. And the only country that succeeded and existed and continues to exist within those boundaries is Israel. So by ignoring these things, the international legal institutions, the Court of Justice and Criminal Court, actually are perverting the rule of law. That is, that the law should be applied equally, that trials should be fair, that laws should be open and transparent and not retrospective, and the judiciary should be impartial. So again, we have this aspect of lawfare emerging, which traduces the purpose and undermines the integrity of international law. So beyond the UN sphere, we have many other battle spaces in the EU Commission, where the cooperation agreement with Israel is currently being reviewed, and where products from Judea and Samaria cannot be labeled as Israeli. And then in the national sphere, there are a range of courts in Canada, the Netherlands, UK, USA, South Africa, Spain, where actions are being taken as lawfare against Israel. Canada has just opened a probe into possible war crimes of dual Israeli-Canadian IDF soldiers, for example. In the Netherlands, there was a recent case to prohibit the export of parts for F-35 fighter planes to Israel. South Africa, we have the genocide case and so on. But it's not just in courts. We also have lawfare battle spaces outside of the courts. We have Zara Cooper here from Melbourne, who was the victim of a concocted apprehended violence order that was ultimately abandoned for her posts concerning Sarah Schwartz. You have Preston City Council in Melbourne flying the Palestinian flag and declaring itself a Zionist-free zone controlled by the Health Services Union delegates who are Lebanese anti-Zionist activists. And also in the corporate sector, you see problems arise. The major New York investment funds manager Morningstar was observed to be recommending against investments in Israel. It was getting its environmental, social, and governance analysis and advice from a Dutch group called Sustainalytics. And Sustainalytics had an established anti-Israel bias and was advising against investment in Israel. And a new group was formed called J-Lens, a group of New York Jewish investors who were analyzing this data and identifying bias, and then going into the board meetings and shareholder meetings of Morningstar and other companies and pointing out bias and therefore counteracting it. So we have lawfare and the countering of it. Here in Australia, my own superannuation fund, UniSuper, has been lobbied by the National Tertiary Education Union to boycott Israel. The Norwegian Sovereign Wealth Fund, the largest in the world, is divesting from Israeli funds, and we've seen other campaigns against Israeli companies such as SodaStream. That's the corporate sector. That we move into the NGO sector, and we see a wide range of NGOs that are mobilized against Israel. Amnesty International and Human Rights Watch, for example, Oxfam, to their own detriment, really, because their credibility is severely damaged by the perception of their politically partisan activity. But they take very definite partisan positions, as do various so-called justice and anti-war NGOs, and particularly Catholic charities. A subgroup of these NGOs are the lawfare warriors that are anti-Zionist, and they involve thousands of people who have been trained as lawyers and tens of thousands of supporters. They're heavily funded. Even when I was sub-dean of the law school in Wollongong, we had a delegation of 5 Palestinian deans brought by retired Federal Court Justice Hal Wooten, who were seeking closer exchange and engagement with Australian universities and funding for Palestinian legal scholars. They scored about $10 million from the Gillard government for master's and PhD programs, and those students are now the lawfare warriors that are leading the battle against Israel in Al-Haq and Al-Mezan and Adamir and so on. Against them, we also have a Jewish and Christian response emerging. thinc, the Hague Initiative for International Cooperation, is the only international law advocacy NGO based in Europe that is undertaking this work in Europe. In Britain, you have the UK Legal Friends of Israel. There are a couple in London. There are a couple in Israel, the International Legal Forum and Shurat Hadin, which you may have heard of. Brooke Goldstein runs the Lawfare project in New York. There's pretty much nothing in Canada. It's really a nascent field. And Andrew and I know pretty much all the people active in this space in the world, because you can count them all on your fingers and your toes. It's not tens of thousands of people. So we're about 3 decades behind in this battle, at least. And as Hillel put it in Pirkei Avot, the saying of the fathers, Imein ani li, mi li. If I am not for me, who am I? And if I'm only for myself, what am I? And if not now, when? And so I invite you all to join our battle, and Andrew will tell you a bit more about how to do that. Thank you.
Thank you very, very much, Professor Greg Rose. We'll hand over now to Andrew if you'd like to unmute and join us.
Thank you so much. Thank you, everybody. Thank you, AJA, Robert, and your team for the invitation to speak. And it's great to see a lot of you and a few well-known faces. So I'm calling in from The Hague in the Netherlands. I've been living here for over 20 years. I grew up in Melbourne, studied at Melbourne University, worked in Melbourne and Canberra, but pursued a career in international law in Europe. And I was taken to London, and my life took a different direction when I ended up in the Netherlands, marrying a Dutch girl. And about 15 years ago, got very involved in Israel and international law, and it became quite apparent really that this whole issue of the use of the legal system really needed a kind of dedicated entity to look into this. And so we set up thinc, the Hague Initiative for International Cooperation. We're based here out of The Hague, just not far away from the Peace Palace, the International Criminal Court, other institutions. We have NATO going on at the moment. Donald Trump is in town, so that's all very exciting. So I just want to share very briefly with you, we don't have much time, what is thinc, what do we do, and how could you possibly get involved and engaged with what we're trying to do. So basically, we're about pursuing justice and promoting peace, and we believe that Israel belongs at the center stage of international relations. That's why in our logo, the letter I stands for international, but also for Israel. It's in the colors of the Jerusalem stone. So our message really is one about allowing Israel to exist, allowing Israel to play its role of being at the forefront of international cooperation, collaboration, supporting international global development, rather than delegitimizing it and demonizing Israel the whole time. So what do? We do research and publications, education, advocacy, and media work. And I want to just briefly talk to you a little bit about how we do that. Our main objectives are fourfold. We want to train a new generation of pro-Israel legal advocates. That's really top of our list is training. We're really developing a whole range of programs, online, offline, in person, in The Hague, in other places, including Australia, to get lawyers together and to really beef up our legal advocacy skills. Secondly, exposing the Iranian regime as a global sponsor of terror. This war, which we've just had for 12 days, is not going away. The revolutionary regime in Tehran has not disappeared. The IRGC still exists. There's a lot of work to be done to be confronting the revolutionary regime. Thirdly, we want to challenge the international legal institution bias against Israel. And that's why being in The Hague is so important. We're very closely connected with the ICJ, the ICC. I have contact with judges at the ICJ, people at the ICC. Geneva is the home of the Human Rights Council. It's not far from us here. So we're really in a kind of a network where we can have an impact. We work closely with the Israelis, by the way, certainly behind the scenes. And fourthly, we want to empower UN member states to push back against this lawfare, especially concerning this push for the two-state solution and Palestinian statehood. So let me just dig in a little bit into that. As Greg says, we're European-based, we're a global network. I think leveraging the Christian and Jewish networks is so important. There's a lot of work, even just in our own networks, of, I think, improving our skills and knowledge, just telling the story of Israel, telling the story of the legitimacy of the Jewish people in the land. Israel has a right to exist, a right to self-defense. It's very basic, but it needs to be told. It needs to be told well. It's basically what we're trying to do. So we write books, we publish papers, we present them. Here, the publication of our book on the two-state solution a year ago in the European Parliament. We're doing a lot of briefings to members of parliaments, both European and beyond Europe. So our publications are important. Two recent ones, we've done one on the IRGC, the Islamic Revolutionary Guard Corps, why it should be listed in the EU as a terror organization. Most recently this year, we've been doing a lot of work around Palestinian statehood in the UN, the International Court of Justice. This is one of our papers. We've set up the Thinc Academy. It's an online platform. We have a range of courses, and I'm very happy to say that Hugh Kitson, who's on this call, his Whose Land production, very important. It's available on our Thinc Academy for people to follow. We also have an Israel on Trial foundational course. It's a 5-module course of 12 hours of lectures by leading academics. You can follow that course by signing up on the Thinc Academy. So just Google the Thinc Academy and you'll find us. We have training conferences in The Hague every year where we get young people together and we run them through a whole series of lectures and workshops and seminars. There we are in front of the Peace Palace. We're engaged in public policy, as I say. We're doing a lot of briefings to the ICC, also to the ICJ, which I'll speak about in a moment in our work for Fiji. Here we are in the International Court of Justice, and I'm sitting next to the Fiji team of the Fiji ambassador to the UN, Filippo Tarakinikini. We've been working very closely with them over the last 2 years and through them with the Pacific Island Group to raise a strong voice into the UN and into the International Court of Justice to support Israel. And this is a growing movement, actually, of states like Fiji, which is taking a very, very strong position, and we're helping them with all their legal research and documentation. And it's having an impact. This is the voting last year on the International Court of Justice advisory opinion. And you can see how small the number of states are who vote in favor of Israel. Here it was only 14. But I can say that 7 of those 14 were Pacific Island states. And the day before this vote, we were in New York briefing the Pacific Island ambassadors on this question. And I think it's clear that our briefing had an impact on their voting. So when we're there, when we and others around us, like us, are able to do these briefings, it really can make an impact even in the UN. The UN is not lost. We're trying to do a lot of work on social media and creating videos, doing interviews, doing webinars and podcasts and so forth. Okay, 2 minutes on the Asia Pacific and then I'll finish. We're trying to raise our work in the Asia Pacific region with Australia really as the hub. And we think there are tremendous opportunities down under. Greg and his team have been doing a lot of work. As I say, we've been assisting Fiji and the Pacific Island states. Greg and others have been writing op-eds in the Australian and elsewhere. Greg's very involved in the academics fighting anti-Semitism, and we're trying to build networks of lawyers and non-lawyers in Australia. We're just starting, but we'd like to really grow that work. We think there are opportunities in Fiji and the UN Pacific Small Island Developing States. PNG is important in that respect. Of course, PNG and Fiji have moved their embassies to Jerusalem, and we think there are more states to follow. Southeast Asia is also I think, a very important field for us to work in. Singapore, Philippines, South Korea, even Indonesia. There are great possibilities, mainly through Christian networks, to make an impact, even in a Muslim country like Indonesia. Okay, so what do we want to do in Australia Pacific? We want to do education, we want to do advocacy and media work. I won't say any more about that in detail, except to ask, say, how can you be involved? Well, you can help us with research and writing. You can be involved in our education. We want to roll out a series of conferences and training programs in different places in Australia. Raise our advocacy voice together with other organizations in Australia, media, networks, and you can help us with finances. So that's my final plug. We do need friends and sponsors to help this work of Think, and this is the web link that you can go to become a friend or sponsor of Think. And I really do invite you to support our work, both here in The Hague, but also in Australia and the Asia Pacific region. So thank you so much. That's my 2 cents, 5 cents worth. Good to be with you, and we'll very happy to take questions. Back to you. Thank you so much.
Thank you very much, Andrew. We have about 10 minutes for questions tonight, but first I'll go to our CEO, Robert Gregory, for a quick update.
Thank you both for an incredible set of 2 talks. Amazing that we can partner with you on this, and I would encourage everyone to get in contact with you and assist in whatever way they can, whether it's financial or other ways, because you're doing really amazing work. I'll just give everyone a quick update. Next week, we will be having Avi Abelo, who's well known to many people in AJA, who'll be giving an update on the war. We can analyze it since it would have been a couple of weeks since it ended, so even since it started. So we'll just see what it means for Israel, what it means for the Middle East. And the other thing I want to quickly mention is the AJA Israel trip. It was always going ahead, but now that the war's over, it's even more going ahead. So there's only a few more spots left. It is soon. Unlike all other trips from Australia, it focuses on Judea Samaria. So I would encourage everyone, if you haven't booked yet, get in touch with Tennille and come on the AJA Israel trip.
Thank you, Robert. And if you would like to see the itinerary, you can email me and I will reply with the itinerary. We'll go with a friend who was mentioned, Hugh Kitson. Please unmute.
Hi, Andrew. It's good to see you. I'm just going to ask you a question which I asked you when we were filming Whose Land. The UN is often seen as a legislative body, which it isn't. What legal right does the United Nations have to impose a Palestinian state within Israeli sovereign territory?
Thanks, Hugh. Good question. You're absolutely right. The UN is not a legislative body. It doesn't make international law. The General Assembly is a political platform. Resolutions of the General Assembly are non-binding political statements. Basically, Security Council can make, in very limited situations, binding resolutions under Chapter 7. It's never done that in relation to Israel. Even 242, 2334 are not Chapter 7 resolutions, so they're non-binding. But look, all of that said, international law really is politics. The whole thing is politics. So strictly speaking, of course, the UN has no power whatsoever to create states or decreate or dismember or whatever. It didn't create the State of Israel, by the way. The State of Israel was not created by the UN partition plan, as many people think. It's a state under international law because it has all the characteristics of statehood. And Palestine doesn't. And this is the thing, it doesn't have a stable or effective or independent government which can govern a defined territory. Just look at Gaza. The PA has no control. You might even say Hamas is a kind of mini-state in Gaza, but it's not really a state under international law, and the West Bank certainly isn't. So this whole push for Palestinian statehood is a political maneuver, but it's using the ICJ, the International Court of Justice, to do it, and this is why it's so dangerous. The court has said last year that in the court's view, the occupations become illegal. Israel must terminate its presence in the occupied territories as soon as possible. And according to the General Assembly, that means before September this year. That means all Jews, all Israelis must be kicked out of the West Bank. That's basically what the court is saying, a Judenrein territory that must become a Palestinian state. And according to the court, that's what international law says as a matter of, and they refer not to so much to the General Assembly as to principles of customary international law. It's very one-sided, but bringing the court into it has given it a kind of a legal framework, which is making it very difficult to push back against. But we think the court is a political institution. Hilary Charlesworth, the Australian judge on the ICJ, she has no idea, with greatest of respect, of the history of Israel, the history of the Jewish state of Israel, and her writings in the court demonstrate this. Basically, the court was hijacked by the Arabs and the Islamic states. It's a long answer to a short question.
Thank you, Andrew. Alan, please unmute.
Yeah, thank you. I've got a question, I think for Greg, but Andrew's welcome to jump in. Penny Wong seems very keen to recognise the state of Palestine, even though it seems like such a preposterous idea. But is a reason for doing this nothing more than to provide an excuse for such a state to exercise, quote, self-defence, as you said, which really just means perpetrating more terror attacks?
Thank you, Alan. I believe that Penny Wong acts out of a deep conviction from student days in a far left set of Soviet influenced values that support the African and Asian nations against the imperial West, and that she views Israel as part of the imperial West. And apart from the hard number crunching that tends to be the determinant of Labour policies in government, I believe that she has that conviction as a fundamental place from which she acts to Israel's detriment. My own experience as an officer of the Department of Foreign Affairs in years past, in the 90s, revealed, sort of a deep hostility to Israel, which is understandable in a bureaucratic context, because that's where the trade is. That's where the international students are. That's where Australia is going to sell its minerals and agricultural produce. And Israel is kind of in the way. If you have to take a moral stand for a small state in relation to 1.5 billion market of global Islamic countries, then the department itself, and particularly its Middle East branches currently constituted, has a mantra which is quite hostile to Israel. She's getting hostile advice, but she comes from a hostile place. That's my interpretation of her motivation.
Thank you, Greg. Please unmute.
Hello. Hi,
Yep.
Greg. So my question is this. Constance Kissinger on Piers Morgan says that the Islamic regime in Iran used children not as child soldiers, but clear minefields. So my question is this. Why hasn't the UN or the International Criminal Court investigated these claims of using children to clear mines, and why haven't they prosecuted those involved using children to clear minefields?
Either Greg or, yep, just on mute.
I can't really answer that question, Anne. I think it's not one that has occurred or has been palatable. For a start, that was in the Iran-Iraq war. So we're talking about the 1980s, 40 years ago, where the Basij, the youth militia, was used to clear mines that had been laid by Iraqi forces. And maybe at some point that will arise. But it's interesting also that in relation to genocide under the Convention for the Prevention and Punishment of Genocide, incitement to genocide is a genocide crime, has been since 1948. Iran is a party to the Genocide Convention, I believe. And there's never been even a murmur of action being taken against Iran for its calls to genocide. So, as Andrew put it, these are essentially political questions that are dressed as law.
Thank you, Greg. Jeff, please unmute.
I think Andrew was going to add something there.
Shalom. I'll let you speak. I'll let you speak. Please.
Oh, okay. Look, just wanted to add, as far as the ICC is concerned, the criminal court, Iran is not a party to the Rome Statute. So the court has no jurisdiction in Iran. And this is the whole thing about the ICC. It's very skewed against Western states. All the main countries that contravene human rights are not even parties to the court, whereas the court's being weaponized to, to investigate and potentially prosecute Israeli leaders for war crimes in the state of Palestine that doesn't exist. So the whole thing is completely turned on its head.
Thank you.
And by the way, I mean, there is room within the ICJ. There are states that are potentially going to intervene on behalf or to support Israel in the case against South Africa. That's one side. And there is a discussion, and we're involved in some initiatives to think about the possibility of bringing Iran before the ICJ for genocide or attempted genocide. And there are different ways that could be done.
Thank you. Jeff, if you'll unmute, we'll squeeze in one quick question before we hit time.
Shalom. Earlier on, Professor Rose mentioned that one of the institutes said that Israel has no right of self-defense with respect to against terrorism. That is the most common piece of claptrap you could imagine. It's absolutely illegal under common law, and you wonder why these institutes cannot be brought to account and sued for and or forced to redact their absolutely illegal things, which are illegal under common law, which is the most basic element of international law, for goodness sakes. And under common law, the Geneva Convention never gets a head up. International Court of Justice and the ICC are also in the same realm. We should be able to challenge every single one of these rulings, which are illegal. Over to your answer, please.
Thank you.
Well, I would say that the International Court of Justice has 15 judges who are appointed on a regionally representative basis for Latin America and the Caribbean, Asia, Africa, Eastern Bloc, and Western Europe and Others Group, which Australia is a part of, and which our Australian judge, Hilary Charlesworth, is a representative of. So of those 15 judges, 2/3 of them are political appointees. There will typically be diplomats. There are legal advisors in foreign ministries. About 1/3 or less will be academics who have been appointed. So our Australian representative is an academic. Her career is one in international law, which has been focused upon international legal theory and in particular feminist legal theory. And her judgment in the preliminary proceedings in the genocide case, as Andrew indicated, didn't reveal any understanding of the actual field of conflict, but dealt with the transgression of women's rights and the intersectionality of human rights abuses, which is her area of expertise, but irrelevant to the question at hand, and is a good example of the kind of academics that you get, woke jurists who really are there to justify their own importance and their own integrity and their own moral beacon to the world. And so they do just the same as the political appointees. They're really on the same page. You will get dissents, and usually there are one or two dissents. In the case that Jeff referred to concerning the finding against the right of self-defense against terrorism in the 2004 judgment concerning the separation barrier, of the 15 judges, 3 dissented: UK, US, and the Netherlands.
Thank you, Professor.
Final point. I know we're a bit over. The final point is, this is depressing. I saw this in the comments. Sometimes it feels overwhelming. And yet you cannot stay silent. You have a duty to speak. And there is that, Hasidic adage that one candle in great darkness brings a wide circle of light. And that's the importance of the work that we do. And that's the reason why you should support it.
Thank you very much, Professor Greg Rose and Andrew Tucker. I think that was a beautiful remark to end on. I can see we have so many people online tonight and a very passionate chat. I would encourage you all to take that passion to get more involved with what thinc is doing, to follow them, to donate, to support, and to really make sure that they have all the tools for the success which we all need for this to have justice and for Israel to triumph. Again, thank you to Ian Warby for his support in putting this together and his partnership. And thank you to thinc for their partnership, and for Andrew and Professor Rose for joining us tonight. It was a fantastic, informative evening. We have recorded this and will be available on our YouTube channel. So I do encourage everyone who's watching tonight, this information is very important and needs to be shared. Please share with your family and friends. Please get these lectures and this information out as wide as possible. Again, thank you very much for joining us tonight, and we look forward to seeing you next week.